Welcome, my dear friends and professional colleagues, to the YouTube channel of Prehit Corporate Consultants India LLP. Today, we are going to elaborate a latest amendment in Companies Incorporation Third Amendment rules, which is with regard to the physical verification of the registered office. This amendment is basically a new new rule which is inserted in Companies Incorporation Rules 2014, and this is in support of Section 12, subsection 9. Basically, under Section 12, subsection 9, the registrar has power to verify the registered office of the company physically to check whether the company is operating or not, whether the company is carrying on any business or not. And under the same subsection, the connectivity is there with Rule 25B of the Companies Incorporation rules. Now, this rule is basically to allow ROC to issue a report with regard to the presence of the registered office of the company, with regard to the operating ability of the registered office of the company. Now, basically, the registrar will visit the registered office of the company if he believes that the company is not carrying on any business or operation. Now, this power is discretionary to decide whether the registrar will visit the registered office of the company under Section 12, subsection 9. But however, the Rule 25 start with the mandatory word shall. But the combined interpretation of Section 12, subsection 9, along with Rule 25B, is that the registrar will visit the registered office of the company only if he believes that the company is not carrying on any business or operation. Now, another thing is that the the physical verification of the registered office will be carried on in presence of two witnesses belonging to the same locality where the registered office of the company is situated. Another thing is that the registrar of companies will basically take the photograph of the premises of the registered office of the companies as well. And ROC has power to take police assistance in case the inspection or verification of the registered office is not allowed to registrar, or there is some hindrance in the process of verification by the company. So basically, if registrar believes that the company is not carrying on any business or operation, and he has reasonable cause to believe this, so he will visit the registered office of the company physically. Definitely, this provision is not there for every company, because ROC don't have time to visit each and every company, but on the discretionary basis, ROC may visit any particular company to verify whether the registered office of the company is there or not. Now, next thing is that in presence of two witnesses, he will do the verification and he will take the photograph of the registered office. But the most important thing in this process is that ROC will verify the documents. ROC will verify the documents on the basis of which you have claimed it as registered office of the company. Like while filing INC 22 or at the time of incorporation, the company might have filed lease deed, rent agreement, ownership proof, or NOC. Basically, ROC will come with the copy of these documents and will verify it with supporting documents. Under the basic Bear Act or law that has been amended, the word supporting documents have been used, but we can refer it as original documents. Basically, the supporting document is basically original document. Now, if ROC has to check whether the lease deed was original or not, ROC will definitely ask for the original lease deed. If ROC has to check whether the NOC was correct or not that you have filed, that scan copy of which you have filed, ROC will definitely ask for the original copy of the NOC from the owner of the premises. Now, this may cause a hardship to companies, because there might be some companies there might be some companies who are not maintaining the records properly, and which don't carry the physical copies of NOC or rent agreement with them. Now, the important thing is that if the registered office is not there, or if ROC believes that the registered office is not capable of being receiving or acknowledging any business communication, now ROC will issue strike off notice to the company and its directors to strike off the name of the company from the records of the company, and company may represent give a representation to ROC within 30 days in this regard. If ROC will believe that company is existing, ROC may allow the company to exist. But if ROC believe that the company is not operating or company is just a paper company, definitely ROC will strike off the name of the company from the register of companies. And ROC may also impose heavy penalties if there is a non-compliance of section 12. Like section 12 basically says that the name and address of the registered office of the company shall be placed outside the premises of the registered office in legible characters. So companies are advised, or clients or friends are advised to maintain all these things properly, to write the name of the registered office of the company in a legible manner and address of the company as well. And it is recommended to write SIN number of the company and communication details like phone number, email address in legible characters. Now, one thing which is required to be kept in mind is that if the local language of the place where the registered office of the company is situated is basically Hindi, and there are people around that locality who don't understand English, or basically we can say if the local language is Hindi, then the name should also be written in Hindi as well, because it is written here that if the characters employed therefore are not of those language or of one of the languages in general use in that locality, so also in the characters of that language, like if the local language is Hindi, then the name should also be written in Hindi. This is my personal opinion with regard to this particular subsection. Now, if the company has changed its name during the past 2 years, always remember you should write the name of you should write the previous name along with the new name for 2 years, and you have to write this previous name in front of the premises of the company as well. Now, another thing that you have to keep in mind is that the registered office shall properly maintain all the registers and records. Yes, your registered office shall be maintaining all the registers and records, because there are other enabling sections in Companies Act which enable registrar to verify your records, and which particular records are required to be maintained at the registered office are mentioned on the screen. These are basically books of accounts, financial statements, memorandum articles, annual returns, register of members, debenture holders, register of directors in KMP, register of duplicate and renewed share certificate, sweat equity shares, register of sweat equity shares, and so many other registers which are required to be maintained on the registered office of the company. And minutes of the meetings of board and shareholders is required to be maintained at the registered office of the company. So basically, we are aware now that registrar can carry on the inspection anytime, and you should always keep your registered office ready for the purpose of verification. There should be a person who is sitting at the registered office. The registered office should not be closed during the working hours at least, and on the working days at least. And if it is closed for some particular purpose, then you should write a notice in front of the basically door of the registered office. It is just a recommendation from my side. Notice, you should place a notice that our office is temporarily closed for few days, or few 2-3 days, or 4-5 days, whatever. So these are the provisions which enables registrar to carry on the physical verification of the registered office of the company. If there is any particular query in this regard, you can write in the comment. I will definitely try to answer your queries. Thank you so much.